Novoselsky was an attorney, and he would enter into, agreements to defend clients, and either the clients or people aligned with the clients would basically advance him a bunch of money where he could, help support his litigation. And he was only obligated to repay it if he won, if the litigation was successful. And so if he got an award of, attorney's costs and fees, he would basically repay the amount that was advanced to him.
Okay.
And so he took the position that these amounts, were all loans, because he said, hey, I might have to pay him back in the future, so I'm not going to pay tax on it. Of course, the IRS comes in and says, these aren't loans because, we don't know for sure. There's no fixed obligation to repay, because if you don't win the case, right, then you don't repay anything. And so we don't think these are loans. And again, this case particularly, okay, it's not the greatest loan versus income case in the world, but it reminds us that, man, right, I teach an entire chapter for University of Denver about loans versus income, because it's not abundantly clear, right? And we know it's not abundantly clear because even the courts have come along to say that, look, we know that if someone loans you money, as we talked about before, I loaned $500 to Damien, that's not taxable income. But if I pay you for some kind of services provided or something like that, and it's income, how do we differentiate between the two in some examples? And so we know, again, it's not a clear determination, because anytime the courts have to rely on a factor test, that means that they haven't been able to figure this thing out either, okay? So I want to go through two kind of cases from previous years, just on a high level, so we can see how the factors work and how it's really hard to kind of predict which direction they're going to go. But this doesn't take long. It's pretty quick. We had a case called Zang versus Commissioner from 2017, and this one I really did find pretty interesting. But husband and his wife worked for a company that was owned by husband's dad, right? So, and this was a Chinese corporation, and these two worked for the company. They took out a really small salary, but they were dumping millions out to themselves every year in what they called loans. And they were using these loans, what they called loans, to buy houses and to gamble like crazy, right? In Atlantic City and Vegas. And, there was no formal documents. There was no interest rate. There was no maturity date. But the IRS came knocking. And the funny thing is, their accountants in this case had told them for years, like, if you want to argue these are loans, you better start paying some amounts back. You better get some formal notes in place. And they didn't do it. And when the IRS brought them into court, they actually said it was kind of insulting for the IRS to require formal documents, because they said it was part of Chinese culture that family members would never expect that level of formality from a loan between, effectively what was dad's company and the kids. So that was kind of their argument. As you can imagine, the IRS doesn't care about what you claim to be, cultural formalities or lack thereof. So they go to a factor test. And the factor tests are all stuff that's totally logical. And different courts use different factors. But if you're trying to figure out, for example, if these amounts were loans or if they were income, they'll look at what ability do you have to repay. And in this Zang case, they're like, well, all the money you borrowed is either tied up in a house or blown at the blackjack table. So you can't repay any of this. So that's not a good factor. Then, of course, they look at the formalities, right? Do you have a formal debt instrument? And here, there was nothing. They drafted something up after the fact, after the IRS came knocking, but there was no debt instrument. Was there a repayment schedule? No repayment schedule. Was there an interest rate? No, right? So they look at the formalities as factors. How do the parties record and conduct or reflect the transaction? Well, they called it loans on the books of the corporation, but again, no formal documents. That's certainly not going to help you. If it's a loan, what do they expect? Maybe you made some repayments over the years. They hadn't repaid anything, right? Has the lender demanded repayment? Well, of course not, because it was dad and they basically controlled the company. And so, what was the likelihood that the loans were disguised compensation for services? In this case, pretty darn good, because They got paid a very small salary to run this company, took out millions of loans that they spent on gambling and houses. And so it probably represented services more than a loan. And so in Zang, they went through the factors and said, you lose every one of them basically. And so this isn't a loan, this is income. Then we had the Kaider case from 2011, Kaider. I thought this one was fascinating when I first read it. But you had a nephew who was disabled, and he went to live with his uncle who had made a bunch of money, self-made millionaire in startup companies. And he lived with his uncle, and his uncle's a rough dude, man. His uncle paid him a small salary, actually a decent salary, but he was also just funding his living expenses. And he was, cutting him checks about $20,000 a year that they all said were loans. They had loan agreements, but the kid would sign the loan agreements, but the uncle wouldn't, right? Mm. And they were supposed to have 6% interest rate due in 5 years. And the uncle told the kid, like, you're going to make so much money working with me, you're going to have no problem paying this back, right? Well, things ended up souring between uncle and nephew. And the uncle, in our tax world, gave the kid the ultimate indignity. What? He sent him a 1099 and said, all those amounts I paid you, they weren't really loans, they were taxable income. And right. So the kid didn't pay tax on it. He didn't even know 1099 had been issued in his name. And so he went to court and said, look, these are notes, these are loans, this is not income for services. So the courts went through the factors and they said, did this kid have the ability to repay it? Well, maybe not at this point, but the uncle had promised him he'd have more than enough to repay because the uncle was going to help him make millions. And so he thought he had the ability to repay when the loan was advanced to him. Was there a debt instrument? Yeah, there was a debt instrument, but the uncle never bothered to sign it. And the uncle, like I said, was a rough dude. He said in the court case that, like, I would never loan to somebody in a 5-year bubble term like that. And then the court went and dug into his finances and found that he had done that many, many times before. So they were not too impressed with him. But, was there an interest rate? Yeah, 6%. Was there a payment date? Yeah, in 5 years. How had the parties treated it? That factor. They had treated it as loans, even if uncle seemed to forget that's how they treated it. They'd always called it loans. Had the kid made any repayments? No, but it wasn't due for 5 years. Had the lender demanded repayment? No, but they weren't due for 5 years. And then they said, could this be disguised comp for services? And they said, no, the kid was paid fairly for the services he provided. This was above and beyond that. And so, when we run through these factors, as opposed to the Zang factors, this kid wins. And so loans versus income, the things we've learned over the years is like, look, if you want to argue something's a loan, you have to have the formal indicia of a debt. You've got to have a written note, a maturity date, an interest rate. You got to have all that stuff or you got no shot, right? No shot. But even if you have that stuff, there's hundreds of cases like these where this is why someone pays us to do our job. If a client is trying to figure this out, we can't say yes or no based on one piece of information they give us. We have to take all their facts, look at the factor test employed by the courts, make sure we have facts that align with each factor and say, do we win? Do we lose, right? And then even if we figure out which factors we win and which factors we lose, the question becomes, is it enough? Is it a loan or is it income? But this is, the first time today we've gone through a case where maybe 104 as well, where the only right answer is the classic tax answer of it depends, right? I mean, you're never going to know for sure. And in this Novoselsky case, just to come back to this one's a little cleaner. They didn't feel the need to do a factor test, although if they had, they said he still would have lost, but they lost for a much simpler reason. Or he lost for a much simpler reason, because for something to be a loan, you have to have an unconditional obligation to repay. And remember, this attorney, he got these advances, but he only had to repay them if, right, he won the cases. And so they said, look, if we had gone through a factor test, there's no formal notes, there's no repayment dates, there's no collateral, none of that stuff. You're going to lose either way. But what we can take away from that, in addition to identifying the factors we talked about before, is if you borrow money and something has to happen before you're obligated to repay it, you're probably going to be deemed to have what we call a claim of right to that money and have to pick up the income, and you can't go treating it as a loan. So anytime, almost anytime, Damien, I see a factor test come through a court case for a year, we're going to end up shoehorning it into our 10, because factor tests are how we earn our keep as tax advisors, right? The simple stuff, right? That's one thing. It's when we can take the complicated set of facts, apply it to a very complicated history of judicial precedent, and conclude on a position for our client that, is either favorable, or if it's not, it's one we can sleep with at night.